Hello, I'm attorney Jordan Bentley with McIntyre Elder Law, and I want to talk about deeds and property ownership. So when you own a property in North Carolina, there's two common ways to own that with someone else. One is called as tenants in common, and the other one is joint tenants with the right of survivorship. So the default way that you own property if you own it with someone else who you're not married to is as tenants in common, which means you each own, if there's two of you, 50%, if there's three of you, a third, right? And you own that property separate from each other so that if you pass away, your share of that property, your 50% or 30% or 10%, however many of you there are and whatever percentage you own, that property will pass to your heirs, according to your will when you pass away. It won't go to the other co-tenants. However, if you own the property as joint tenants with the right of survivorship, you each or you all, if there's more than two of you, own 100% simultaneously. So that if any of you were to pass away, your interest just goes to the other person, right? So if two people own property as joint tenants with right of survivorship and person A passes away, well then person B just owns the whole property, right? The person A's heirs don't get anything. If you own property as a married couple, and I hinted at this a moment ago, you automatically in the state of North Carolina own it as something called tenants by the entirety, which is also a joint tenancy with the right of survivorship. If you're curious about the status of your property ownership, you want us to look at your deed and discuss it with you, figure out the best way to make sure that property passes to your loved ones, give us a call at 888-999-6600 or go to mcelderlaw.com/scheduling and sit down and talk to one of our attorneys.